one, Your Honor, because I had filed motions to quash the subpoena, and I believe that the court ruled at a previous hearing that the court didn't have the authority to do that, or something to that effect, or it was there was some reasoning that the court gave previously with regards to those motions, but there was another one that Ms. Sabelli filed in December.
And actually, Ms. Sabelli, are you handling these motions?
Yes, Your Honor. I'm handling the motion to quash. And just for clarification, I did file the motion to quash. However, Ms. Bell did file or reissue those subpoenas, so I went ahead and refiled my motion to quash with some modifications.
Okay. Ms. Sabelli, do you believe that I ruled on the October 15th motion already?
I'm unsure.
And I'm confused because I had filed motions and she had filed motions, and so I don't know. Did you file one in October as well?
Yes, my original motion to quash was filed in October, and then the second one I filed was filed in December.
Okay. But you don't know whether Ms. Ortman seems to think that I rolled on the October 15th one, but you're. I'm not sure that I have, but I'm sure Ms. Bell will have an opinion on that too. But do you believe I've rolled on the October 15th motion?
I'm not certain, Your Honor. I don't believe that I've seen a ruling come through,
okay.
But I did see that she reissued the subpoenas, so we still have to address those reissued subpoenas.
Okay, so Ms. Bell, what are your thoughts on how we should handle all of this today?
Addressing the motion to quash first, procedurally, I had asked the court to issue the subpoenas. There's a statute that allows the court to issue subpoenas. The reason I went that route first is because in cases like this in the past, where prosecutors and the prosecutor staff are deposed and called to the stand, I went through the court to have the subpoenas issued. The court did issue the subpoenas, and it eliminated motions to quash later down the road, saved time, we didn't have delay. What happened at the hearing is the court had indicated that it had never really been asked to sign subpoenas, and while on the bench in the past, and said to get them through the clerk, which is what I did. I had those served on October 1st. The court, when we set this hearing for today's hearing for October 27th, I had proposed first addressing my intended subpoenas and doing that hearing first. The state wanted to set the hearing, so what the court did on the 27th is it had set us, but you had a trial that day that you weren't sure if it was going to get vacated. The trial went forward, so the court continued the 27th to the 18th. My reading of the rules, the subpoena stay in effect unless quashed by the court. To avoid any confusion, and because the witnesses are non-responsive, rather than email them the date and maybe them not get it or get lost in the mail, I had the subpoenas reissued with a new date so there could be no confusion, and it served on each of the witnesses by the constable. The court did not rule on the state's October motion to quash. The subpoenas were not quashed. I don't believe the court quashed them when they continued the hearing. They remained in effect, and they did reissue them simply to give the witnesses notice of today's date because the hearing was continued, and I just didn't want there to be any confusion by the witnesses and someone not show up and cause delay.
Okay.
And then,
so let me state what I think I remember. Actually, I think I remember it about the way Ms. Bell is explaining it. And I think the court's statements earlier were that the subpoenas could be issued, but we would still take. I mean, my thought process is the state would still be able to argue that the subpoena should be quashed, but that the court generally doesn't have anything to do with issuing the subpoenas. So it seems that maybe that issue is an issue, and I'll stop my interruption and let you explain more, Ms. Bell, but it seems that the issue of whether or not the subpoena should be quashed is maybe something we need to address first anyway. If they're quashed, then that affects the other motions. And if they're not quashed, I'm sure that Ms. Bell will want to call those individuals as witnesses. So, Ms. Bell, I interrupted you. Go ahead.
Just for the motions to be argued today is there's basically 3 different motions, but they all overlap. So to make a very long story short that we're going to look at over the next few hours is there's a course of conduct by the state for March and through July and August. That's at issue, which prompted various motions. The first one is a motion to dismiss for vindictive prosecution. Also for interfering with Ms. Lopez's right to counsel and for interfering with Ms. Lopez's right to prepare defense and interfering with witnesses. Those are all bases for the motion to dismiss. And then that conduct not only allows the court to dismiss prosecutions, you can also disqualify and impose sanctions pursuant to 15.7. So the best way to work through these motions is to go through the course of conduct. And really, these are just remedies for the course of conduct over the last 4 months. The court has a variety of remedies that it can impose to address it. And of course, the court can do nothing, which obviously is not my hope. But the motion to dismiss, the 15.7 and disqualifications are all remedies. So how I plan to present the case, Your Honor, is to bring in the relevant witnesses, starting with Ms. Harmon, Collins is second, and go through what has happened in this case from March through July that is the basis for each of these motions. So those are the 3 motions that I think the court will be addressing today, and the same conduct overlaps for all of those motions. Those are really just remedies for the court to address the misconduct that's happened for at least 4 months.
Okay. So it seems that there's general agreement that the court has to decide whether or not to quash the subpoenas. And we're talking about subpoenas for Mr. Collins, Ms. Harmon. Did you also subpoena Ms. Ortman? Was that one of them? I remind me.
Your Honor.
Oh, Misty Price. So those 3 employees from the county attorney's office, Ms. Price, Ms. Harmon, and Mr. Collins. Okay. Well, why don't we do that? So the state's filed 2 motions to quash. There was a lot of overlap, I think, in the two motions, and maybe that's just, I understand procedurally now, since the new subpoenas were issued, the state wanted to make sure that they were preserving all their arguments as to the new subpoenas. And the defense asked for the second set of subpoenas to be issued because they wanted to preserve their argument to be able to have those subpoenas issued and have those witnesses testify. I've read the motions, and again, I mean, I didn't set them side by side, but it seemed like there was a great deal of overlap between the 2 motions, which I think makes sense. I note, Ms. Bell, I don't believe that I saw a response as to the second motion to quash. I'm guessing that it would probably read about like the response to the first motion to quash because of the overlap. But do you have any problem going forward with just the arguments on the motions to quash today, even though I think probably you still have time? It's the 18th. I think it was filed the 10th. I think you still have time to file a response if you wanted to. Are you okay arguing that today, not having had an opportunity to respond to the second motion to quash?
Hey, Sean, I'm ready to argue. We have all 7 witnesses. I think it's 7, all right. They're here. They're taking the time out of the day. I know the court's blocked off its day. I don't want to reserve another day on the court's docket. Drag 7 more possible witnesses here to reply. So I'm ready. I didn't get a chance to set them side by side. They looked identical to me. But I have my arguments as to why they're relevant, and I'm ready to.
Okay. So, and Ms. Schiavelli, are you going to be arguing for the state then?
Yes,
I'm assuming
Your Honor.
since you wrote the briefs. Okay. Let's talk about the motions to quash. So go ahead, Ms. Schiavelli.
Yes, Your Honor. You're right. There is a lot of overlap in our second motion to quash, and that is because these are identical subpoenas, and the state's position does not change. Procedurally, this is highly improper to issue these subpoenas. The state is in the position that this is another means for defense to harass the county attorney's office and to try to disqualify the county attorney's office. The one addition that I did add to the second motion to quash was referencing the new appellate court decision, State v. Fish of Maricopa County. In that case, the state designated an officer at the state's table basically to assist the state in their case. The investigator was not assigned to the original investigation of the underlying criminal case. They were just present at the original trial. There was a mistrial declared. When the new trial came about, defense was trying to seek those documents that the investigator had. He was taking notes during the trial. Defense counsel sought those items for disclosure. The court granted it, and that's how the special action came about before the appellate court. The appellate court reviewed, and in fact, they found that there is no constitutional right to discovery. They indicated that the investigating officer was not there during the actual crime. None of his testimony would have had any bearing on the criminal case, and therefore they excluded his testimony. In my original motion to quash, I referenced the relevant rule, which is 15.5. In 15.5, the court has the ability to quash subpoenas as well as issue protective orders when the requested testimony is irrelevant, duplicative, and unnecessary. In this case, when defense filed their reply, I did not see any indication as to why any of the testimony solicited through the subpoenas is relevant and that it was necessary and that she wouldn't have been able to obtain it by any other means. In fact, she has submitted many public records requests. I'm not certain which ones were picked up and which ones were not, but she has all of those documents available to her. The grand jury transcripts were also made available to her. So the state is asking specifically if defense counsel could explain to the court how any of the testimony is relevant, how it's necessary, and how it's not able to be obtained by any other means.
Okay. Ms. Bell, your response.
Okay, Judge, before I start argument, I uploaded 99 exhibits. At the last court appearance, Ms. Ortman stated that I don't have any issues with any of the exhibits that she's attached in the court considering any of those. I think that's appropriate. So my first matter of business is there any objection to the 99 exhibits that have been uploaded? Because that will affect part of my response to the motion to quash.
Your Honor, I checked my email this morning. I didn't have, the only case lines link that I had, it had nothing in it. There were no exhibits. There was nothing, and I checked this morning, so I haven't seen it. If they're all, and Ms. Bell, if they're all exhibits that were attached to your motions that you had filed, and it's all the same stuff that you had attached to your motions, then no, I don't, because I've seen it all before. If there's something new in there that I haven't seen, I just ask to be able to see it, and so maybe we could put case lines up on the screen or something like that.
Judge, can you see them?
I am getting ready to log on to case
I
lines.
can hand you my iPad and go through.
However you want
Most
to do
of
it.
them are. I did.
Do we have
For example,
one?
there's an email.
Hold on a second.
Yeah.
Do we have, have you been on case lines?
Yes,
Is there 99? So the clerk says there's 99 exhibits on case lines.
Yeah. So I just wasn't. I checked my email this morning to try and see it, and like I said, the only link that I had received, it had 0 things in it, and so, I'm not objecting necessarily. If I could just see them, or maybe we could put them on the screen, or if I could look on your iPad.
Yeah, we just hand this down to her. It's up, just scroll. 100 and 101 are not up there. Most of the first 50-ish or 60-ish or what has been attached. Then there's like grand jury transcripts, pleadings, a screenshot. Like there were 2 emails where it didn't show the date or who was attached. So I screenshot it so you can see who's attached on what day. But there's nothing like that I went out and got that wasn't like sent by the state. The only thing is Bloom's email to Graphius about the public records request, which I think is 99.
I just hit back and it went somewhere, and I am not comfortable poking around. I'm
It
just going
says
to bring
like
it over.
filed. Oh yeah.
I'm not comfortable poking around on that.
Swipe up and then it's the file.
And so it was. I looked at 99, and you said,
And 99 was the only one that you probably would not have seen.
yeah.
Because that's from Will.
And I just looked at that. So everything else is like emails and stuff like that.
Yeah, like screenshots of the emails. Like it's mostly all stuff that's my PowerPoint that.
Oh, I'm sorry.
No, that's fine because I'm going to see if they have an HDMI. If not, I'm going to email that to you anyways so that you can follow along.
No, it's
And for whatever it's worth, I am on case lines now. I see there are 99 exhibits. I've kind of skimmed through them. I don't know that I've read even the titles of all of them.
So I don't have an objection to 99. That's fine.
Okay. So for purposes of today's hearing, these 99 exhibits are admitted into evidence.
Yeah, so turning to the motion to quash, my response would be for both. This second one would be nearly identical. So first, I'm going to address some of what the state's argument was, and then I'm going to answer the state's call as to why they're relevant. So the claim that this is highly improper lacks merit. For Your Honor, there's no prohibition to calling prosecutors or their staff in a trial. There's no case law on that. What you may find is when a advocate is acting as a witness in a trial before a jury, and there's specific policy reasons behind that, and it's still not a prohibition. What often you'll find in that case law is that when a defendant elects to call a prosecutor's office in front of a jury, that it would affect the defendant's ability to disqualify that office. First of all, we're not in a jury trial. Second of all, my motion to disqualify has not to do with their role today in taking the stand today as witness and advocate. So that's not the purpose for the disqualification. You are not a jury. You are a judge, and you know the difference between argument and evidence. So the policy reasons as to not allowing prosecutors in some cases to take the stand is not present here. Plus, Your Honor, what would happen is when a prosecutor is called to the stand, what the state may do, what any attorney may do, is assert an evidentiary privilege if it applies, but they must meet that. So this is not highly improper. It might be something that this prosecutor's office hasn't seen. However, the issue before this court is prosecutorial misconduct. The only witnesses about what the prosecutor and their staff have done in this case rest primarily with the prosecutor. The 2 cases that the state cited in their motion to quash, actually there was an evidentiary hearing before a judge, and the prosecutors were called to the stand and cross-examined by the defense counsel in both of those. So that's what we're doing here today. Also, it would produce an absurd result if the state could say, Judge, we're the prosecutor and we committed misconduct and all the witnesses are in our office, and you can't call us to the stand, so it looks like you can't prove it. There's a case on point that said because of the evidence and the witnesses are in control of the state, it is very difficult for the defense to gain access to that, which you've seen here, Your Honor. They brought in a series of attorneys against one attorney to litigate this, and we're going to get into the public records bankruptcy request and the private law firm they've hired to stonewall that. They have not given it. So it's not a means to harass. Your Honor, in my motions, I attached multiple emails to the state trying to just cooperate, to resolve, to get access. And the state has over and over and over, which we'll go through in the timeline and through the witness testimony, refused. So to say that I'm harassing them would be completely unfounded. You can't harass a party that you keep saying, these are the rules, this is the law, that I'd really like to work with you, I don't want to file a motion to disqualify, let's do this, and the state is the cause of this. So the motive, they're saying that I'm subpoenaing these witnesses as a means to disqualify. First of all, I didn't move to disqualify for their role today in this hearing as witnesses. Second of all, the motion to disqualify has to do with the interference to the right of counsel. There is so much authority on point. I've only included a handful in my PowerPoint, but the most important case, which was cited by the Arizona Supreme Court case, says this. The Arizona Supreme Court will not tolerate any interference with the right to counsel. And that once the state has interfered, it does not matter if there's no prejudice or another attorney was present and competent, there is an inescapable appearance of impropriety, which that alone is grounds for disqualification. So to say that I've subpoenaed these people to harass and to disqualify is just false. Your Honor, what I say, what Ms. Ortman says, is not evidence. The court is not to ground its determination on these motions on the credibility and integrity of the attorneys. That's in my motion. So what would happen is all you have is a whole bunch of exhibits, which quite frankly do not help the state. You would have to you'd have to rely on vouching by me and the prosecutor and speculation because the witnesses can't come in and explain why they did what they did. For example, there's a screenshot and there's multiple motions that show Ms. Harmon did not reach out to my office to schedule interviews from May 6th through July 17th. No, that's 2 months. So, of course, I'm going to argue she was told not to. The state's going to say that she didn't. If she says that she did, well, she needs to take the stand, and she needs any facts that come in, you have to be sworn under oath. That's the rules. Or she can't vouch. So you need to hear from Ms. Harmon why. Did Ms. Ortman tell her not to? If she did, then that's egregious. If Ms. Harmon just decided not to, the conduct is still imputed to the state, but it's a lot less egregious. So you need to hear from these witnesses why they did what they did. I cannot tell you why, and neither can the state. That's vouching. So for you to get to the bottom of the truth, to hear from the witnesses, to have evidence, you need witnesses, not just 99 exhibits and arguments, because that would require speculation. And judge, quite frankly, the states come in, they've asserted facts to you that are wrong. For example, at the last hearing when we said this, Ms. Ortman told you that she responded to the settlement conference court and said that it did not refuse to come to the settlement conference. I admitted the correspondence from the judicial assistant. She never responded. She lied to this court. She never responded. Ms. Skybelli, I'm sorry, I know I probably messed your last name up. It's Sabelli, stated that the defense did not file a motion to extend the deadline to remand. Yes, we did. It was granted. You signed it. It was 45 days. They're getting the facts wrong. They don't even know the facts. They've also cited, Ms. Ortman cited, to an unpublished opinion that's not supported by Rule 111C, and provided this and withheld from this court Robinson v. Hawthorne. The state's not giving you the accurate law on point, it's withholding it, citing the unpublished opinion, and it's not telling you the true facts. You should not rely on vouching, because one side before you today is not getting the law right, it's not getting the facts right. You should call these witnesses so that you have a clear picture and you can make the best record and the best decision, because at the end of the day, Your Honor, there's a defendant here who's looking at 10 years in prison, at least. That's the presumptive on the class 2. And if you stack her sentences, it could be more. It's her life at the end of the day. She deserves her day in court. So the prosecutor's suggestion that you rely on vouching has been rejected by the court. Also, State v. Fish. It's distinguishable. First of all, something very important that the state said, that the defense tried to compel a document. Ms. Harmon, Mr. Collins is not a document. They are not tangible beings. So the fact that they are trying to assert work product, these are people. This testimony. This is not work product. This is not a document that was prepared by Ms. Ortman. So Fisher is distinguishable. Also, he was not necessary because he wasn't a witness to the events in the proceeding, which was trial. In this case, Ms. Harmon, Mr. Collins are witnesses, and I'll tell you what they both did here in a moment. So the case that the state cited on is distinguishable. So the state said that there are other means. First of all, the state is the reason they're in this position at this very moment. They are the reason they're responding to the motion to dismiss, the 15.7, the motion to disqualify. It was a very easy resolution, Your Honor. All they had to do was acknowledge NAP counsel. The problem is Ms. Ortman doesn't understand the law. And so she ran afoul of it over and over and over. And instead of admitting she was wrong, she doubled down on it, and then she committed more misconduct. And they had a chance to remedy this before the settlement conference passed, before prejudice, before vindictive prosecution, and they chose not to. I made a discovery demand for 15.1. The state did not respond to that. They could have given me the emails that I asked for when I made the discovery demand, which they didn't. Instead, I made a public records request. Your Honor, they went and hired Joan Skelton and, it's like 5 names, Exhibit 53. Exhibit 53 for that. Joan Skelter and something, I don't know, it was like 4 different names. A big law firm downtown that probably charges a lot per hour. Just to stonewall. He's sending letters, he's sending like all this case law saying you can't get it in a public records request, you can't get it in a 15.1, and it's the state's position you can't have it in a 15.1. So no, Your Honor, the county has actually engaged in a coordinated effort to make sure that the defense cannot get these records. Mr. Bloom has been retained to represent the public records request, and we're 4 months in, and he's still litigating it. He's out sick right now because he basically asked what everyone else does. But no, there is no other means because the state's ensured that there is no other means. Also, all of these witnesses, I sent a letter, Your Honor, to all of these witnesses, and it's attached, I believe it's Exhibit 80. Collins was a different one. His was separate. And it basically said that I asked to interview all of these witnesses so that I could, 1, prepare the case, but 2, not call unnecessary witnesses, not waste the court's time, expedite the hearing, and if they were not necessary, I would relieve them. They didn't respond. The state has had all of these avenues towards them to avoid the position they're in today. Mr. Collins was in here before you came in. He has no objection to taking the stand, Your Honor. I'm really confused, quite frankly, by her motion to quash because he was in here with this monster saying he's excited to take the stand. He wants to testify. So why is there a motion to quash? And it's because the state wants to quash the motion because what he's going to tell this court is not going to make the state look good. So let's start with Ms. Harmon. I came on this case in March, and I filed my notice of appearance. For 4 months, the state interfered with my client's right to counsel, refused to give pleadings, refused to give discovery. And then when we removed the public defender, tried to get a public defender appointed over my client's objection. They stopped giving pleadings to me, Your Honor. Ms. Harmon was instructed to stop giving me pleadings, not to send me discovery. And, Your Honor, the interview suddenly stopped on May 6th when I came in to interview on May 10th, and Ms. Ortman discovered that I would be doing the interviews. And then we submitted a deviation request. Barry Standiford went over her head and went to Beauchamp. And for 2 months, Harmon mysteriously stopped arranging interviews. And that's because she was told. And that's what we're going to prove today. And she's going to also testify why she stopped giving pleadings. There was a motion to appoint a public defender over my client's objection. And when we filed the motion and Barry joined in that I would assume the case, they withheld that from me. They withheld the motion in limine to preclude evidence that we were going to use in her defense and trial. They withheld the response to my motion to remand, all by instruction of the state. So if Ms. Ortman told Ms. Harmon not to give an attorney of record pleadings, that is a Sixth Amendment violation. So she is a relevant witness. Your Honor, that's just some of what she did. These are only some of the exhibits that she's going to testify that proves all of this. Mr. Collins, what happened after the state refused to arrange interviews? I reached out to Valenzuela because he was the one witness that responded and was being cooperative. He reached out to the state to try and help because we had told the state multiple times that these interviews were with Palmer, was exculpatory, it was necessary. We laid it all out, Your Honor. I'll show all of this through the testimony and the exhibits. It was very clear. Valenzuela is going out of his way to help the defense. I get an interview after we filed a motion to disqualify when she pulled the plea and tried to have another public defender appointed and have me removed from the case. And I arranged an interview with Palmer. Well, Collins found out about the interview and called and canceled the interview. The state does not own the witnesses. They cannot cancel interviews. They cannot interfere. And they did. And then they tried to demand that they would schedule my interviews. And I perfectly clear. The defense has a right to schedule their own interviews. We do not need the consent of the state. I have all of the case law in the PowerPoint, Your Honor. I won't go through all of it now. And what they did is they sent letters, and they singled out Valenzuela, and they sent him a letter because he was the one trying to assist the defense to get access to Palmer, which the state spent 2 months making sure never happened, and basically made it very clear their expectations of him. Do not consent to a defense interview without the presence of the state, and demanded that she schedule it, which is witness interference. So Collins is going to testify why he canceled, why he reached out, who he reached out to, because that's interference. So these witnesses are relevant. For Misty Price, Valenzuela reached out to Misty Price to schedule not only his interview, but to assist in Palmer's. And nobody scheduled it. These witnesses did not schedule the interviews because they were acting at the direction of Ms. Ortman. And if they were not, if they come in and said, no, we just didn't do it because we didn't feel like it or we were busy, it will still be misconduct because the state has it's Ms. Ortman's obligation to be diligent, and she agreed to arrange interviews. And in fact, if the defense tries to arrange their own interviews, the state will just interfere. That's been made clear as day by the exhibit. So these witnesses are relevant, Your Honor, and the court deserves to hear why they did what they did. Because if it comes out that it was at the direction of Ms. Ortman, this court has grounds to dismiss the 091 case with prejudice for prosecutorial misconduct, vindictive prosecution, witness interference, interfering with Ms. Lopez's right to prepare defense, and interfering with Ms. Lopez's right to counsel. It could also disqualify the entire office, and Collins will, and all of these witnesses will testify to whether or not screening measures have been put in place, which is the fourth factor on a disqualification. It also will determine culpability under 15.7 and the severity of the sanction. Otherwise, Your Honor, you have two opinions from two prosecutors or from two attorneys as to why these witnesses did what they did. And Ms. Ortman has already been proven, and Ms. Skybelli, to get the facts wrong. So you need to hear from these fact witnesses, not from the prosecutors. This is just an effort to minimize the evidence to come in that's going to jeopardize the state's case. The fact that Mr. Collins was in here, happy and joyous as can be, and wants to take the stand, goes to show it's not his decision that he doesn't want to testify. It's a coordinated effort designed to protect the state's prosecution, to hide their misconduct, and to prevent access to witnesses that are in possession of facts and knowledge, not work product, not attorney-client privilege. Ms. Ortman does not represent these witnesses. That's Roman v. Catholic Church. So there is no attorney-client privilege. I'm not going out. No privilege applies. They didn't even need that burden on that motion anyway. But even if they try, they're not going to. So these witnesses need to testify. Otherwise, Judge, you have an issue of vouching. You create an appeal issue, and it can all be avoided. They're here. Most of them want to testify. Let them do it. The only person that's trying to protect their interests and block access to this witness, and they have tried, Your Honor. They have hired attorneys and wasted taxpayers' money. They've refused to waive service. They've had the constable have to serve them. They've had Ms. Skybelli brought in because it is imperative that you do not hear from these witnesses, because what these witnesses have to say is going to blow this court's mind. I do not see how the appearance of impropriety can ever be overcome based on what's happened in this case and the case law. So if Ms. Ortman's going to result to vouching, I'm going to move to put her on the stand, and I have 100 exhibits, and I'm ready to cross-examine her. But I will object to her acting as an unsworn witness, particularly as she's lied to this court, withheld authority, cited to unpublished authority that's not permitted, and misled this court multiple times. So we ask that you let these witnesses come in, give Ms. Lopez her fair day in court, because for 9 months she has not been treated fairly by this office, and we want to prove it. So give us our chance. Let us hear from these witnesses. It's not privilege, and the claim of harassment, what is it, like unheard of, highly improper, and the case law they rely on is not applicable here. Thank you.
Ms. Skybelli?
Yes, Your Honor. In my motion to quash, I did reference U.S. Enterprise, and in that case, Your Honor, the court specified that subpoenas cannot be used as a tool for speculative discovery aimed at uncovering alleged prosecutorial misconduct without any factual foundation. Here, defense is arguing that there was some comment made to Nikki that she should not be setting up interviews. That is just an assumption, Your Honor. That did not take place. Just like Ms. Bell is assuming that we hired private counsel so that we can hide evidence from her, that is certainly not the case, Your Honor. When public records requests are submitted to the county attorney's office, that involves the civil department. Mr. Joe Albo worked on 2 public records requests with the assistance of Athena Gooding. And in response to those public records requests we were going to fulfill, Ms. Bell turned around and submitted public record requests for Mr. Albo and Ms. Gooding's documents. At that point, that's when the county attorney's office decided to hire private counsel because we realized that this was not going to end. Your Honor, there's another case which references the specific testimony of a prosecutor as a witness. Ms. Bell was just indicating that there is no case discussing the prosecution of a witness. There is no compelling need for their testimony. In the case of State v. Tuzan, the court found that for a prosecutor to testify, defense needs to show a compelling need for their testimony. In the rule that we discussed earlier with the court's ability to quash these subpoenas, 15 my apologies. In Rule 15.4b, Your Honor, it discusses the work product of the prosecutors is not disclosable and it's not material as evidence when it could be obtained through another means. There was also a court that indicated that if there was some sort of testimony solicited from government employees, it needs to be relevant and material. It needs to be directly relevant to the key issue in the case. Mrs. Bell's arguments do not indicate that there's any relevancy as to the issue in this specific case. There's also the obligation of defense to show that there is no other means for these documents. And again, Your Honor, Mrs. Bell has submitted public records requests. She is in receipt of all of the emails that she has requested. Our private counsel has been in communication with her private counsel about her records requests and how they're unreasonable and how it would take county staff many weeks to fulfill her unreasonable requests. Now, we have not received a response from her attorney. I'm not sure if she's being represented still. However, her requests still are in the office and she has not paid for them. So I'm unsure why she would submit a request if it was not going to be picked up but for to harass the county attorney's office. There's also a mention about the criminal chief and how he was eager to get on the stand. Absolutely, he's eager to get on the stand. It doesn't mean that the state's not going to object to these improper subpoenas. We absolutely are, but he's not opposed to going onto the stand because there's nothing for him to hide. Again, Your Honor, the defense has failed to identify a key issue in this case where the testimony of these witnesses would be relevant and necessary and that she's not able to obtain them through another means. The state urges the court to quash the subpoenas and issue a protective order to prevent Mrs. Bell from doing this any further. Thank you.
There were some false statements of fact. Do you want me to correct them?
I'll allow you to point out what you think are the false statements of fact and the prosecutor's motion, then I'll give the prosecutor another opportunity. Go ahead.
First, she made the statement that I have all of the documents. That's not true. For example, there were emails from Barry Standiford to Miss Ortman that basically is exhibit number. For example, exhibit number 2, which should have been included in the public records request, which wasn't, which alerted to me that they did not include all of the available documents. And so I made a second request. So she said that I received all the documents. That's not true. What happened is it was clear that they withheld documents, and that's when they brought in Derek. So then she went on and said that it's unreasonable and there's all these documents that they're going to have to go through. So clearly I don't have them. And she also said that there's public records requests that haven't paid for. I did pay for the few that they were willing to get before they brought Derek Graffius in. And I did pay for those, Your Honor. In fact, exhibit, I want to say it is exhibit 33 and exhibit 33 was from the public records request, which I couldn't have gotten if I hadn't paid for it. So saying that there's public records requests that were available that I didn't pay for is not true. They gave me a few, they withheld me. So I made another demand. That's when they brought in Graphius, and that's when they brought in Bloom. They have not complied with it. And it has been proven that the state will come in to this court, make a claim of fact, and then the court's finding out later that it's false. For example, Ms. Ortman told you, I didn't refuse to respond. And then I reached out to the settlement conference court, and they confirmed, because I never saw a response, that she never responded. So it allows the state to do what they just did, and they're vouching even in their own argument, and give you false facts instead of calling the witnesses. So there again, most of what she said is vouching, but also she doesn't even know the facts of this case. She didn't even know that the grand jury was extended. So her inability to recognize the materiality and the relevance of these witnesses is nominal at best. She never reached out. They never asked. They're only interested in making whatever argument to prevent access to these witnesses. The cases that they rely on for witness advocate is the assigned prosecutor, Ms. Ortman, testifying before a trial. Mr. Collins is not the assigned prosecutor. The witness advocate rule is not barred. And the state vouched in its arguments for facts without taking the stand, and they got the facts wrong, which is exactly why you should not resort to vouching from these witnesses as arguments for facts.
Ms. Chiavelli, I said I'd give you an opportunity.
Yes, Your Honor.
Reply.
Mrs. Bell is vouching herself, so I'm not sure where this is headed, but the rules are the rules. The court does have the ability to quash these subpoenas. I do not think that defense has met their burden in advising the court why these are relevant and necessary. And as I explained in the case law, they must be relevant to the underlying case. Here, they are certainly not. Again, Your Honor, we're just asking that you quash all of the subpoenas and issue protective orders.
Let me ask a question. So as I understand the defense argument, it seems that all of these motions even after the court decides the motion to quash the subpoenas, the issues are all the same in all of the motions. I mean, they're certainly tied together. As I understand generally the defense argument, it is that Ms. Ortman, from soon after the time Ms. Bell first began to represent the defendant as NAP counsel, and up to about July or August of this year, improperly did not communicate with Ms. Bell, and only communicated with defense counsel on the case. It seems that the argument is that around July or August or sometime like that, and it's probably about the time that Mr. Staniford withdrew from the case, that the state has been communicating with Ms. Bell. And assuming that, without deciding that all of that is true, what difference at this point do these witnesses make for the defendant's case now? I mean, if there is, what, other than the passage of 4 or 5 months, and again, assuming that Ms. Ortman improperly refused to communicate with defense counsel for 4 or 5 months, that period of time. But the county attorney's office, maybe lately, but has accepted the fact that Ms. Bell is the defendant's attorney. What prejudice is there to, I mean, I'm having a hard time understanding what prejudice there is now. If I know there were arguments about plea offer being withdrawn. I think I saw in one of the responses that the plea offer has been reopened. Help me understand the prejudice.
I didn't read I never read the plea reopen.
I don't know if I've read so many things in the last couple of days. I'm conflating something, but
the last setting on the record, I have the transcript. Ms. Ortman stated that there is no plea. These cases need to be set for trial. So I didn't receive it, but Judge, maybe I can clarify. What I was trying not to do was to get too much into what the witness, like all the stuff I'm going to be going through with the witnesses, which is going to take hours of the court's time. And then in the PowerPoint that I have for the court, it ties all the case law and how all of these issues, right? You've got 4 significant issues and how they all overlap with the law. It's very complex. So it's more than just Ms. Ortman failed or refused to communicate with me, but was communicating with Barry Stanford. That's not the issue. If that had been the issue, we would not be here. What happened is that when I filed my notice of NAP counsel, what the cases say, NAP is just basically signals, hey, I'm not replacing the public defender, I'm associating. And you refer to NAP because that was the Arizona Supreme Court case, but there's a lot of case law on there. It gets overwhelming. I cited some of it in the PowerPoint and the closing argument I'll make. But basically, once I came on, there's a number of things that the county cannot do, which the county did, all of them. First of all, I have a right to receive discovery of reciprocal rights under 15.1. I have rights to basically just participate in the defense. So what ends up happening wasn't that Miss Ortman just didn't communicate with me for 4 months, that there's no prejudice. What happened is she interfered with the right to counsel. Here's the problem. And this is the case law that I put in the PowerPoint, Your Honor. I also create a folder of all the cases in my PowerPoints, like 26 cases. I can send them all to the court so you don't have to pull up each one. But basically it says that 2 things are very important to the right to counsel violation. It's 1, prejudice does not have to be shown. Prejudice is irrelevant to the analysis. The second thing is that it is irrelevant that a competent attorney represented the defendant anyway. So say, hey, you know what? Our bad. We messed up. We don't know the law. But we did give it to Barry Stanford, so judge, no problem. That is irrelevant. Excluding associated counsel is a violation. And then the most important, the most significant is that you do not have to show prejudice, and it creates an inescapable appearance of impropriety. And when you start talking about disqualification, the court, even if you could look at this, put it all down on paper, reach into her soul and see if she had good intentions and this was just an accident and she's not really vindictive. It's the appearance of impropriety to the public. And because there's an inescapable appearance of impropriety, and it doesn't matter that maybe you don't find actual prejudice, which there is, Your Honor, and that Barry Stanford was talking is irrelevant. Once that right to counsel violation occurs, it's done for the state. That's why I'm mind blown that they went this route. But there was still time for the state to fix it, but they chose not to. So saying like, well, here's why everything is stopped in July and August. A barrage of motions came in to this court. Motion to disqualify, the motion to dismiss, the 15.7 sanctions, motion to depose, subpoenas. Basically, everything leading up, we started preparing for this hearing. So everything came to a standstill, and presumably the misconduct stopped because we started litigating the misconduct. So just being like, well, since August, she's been communicating. That's not true. This case, the actual case, has been derailed for 9 months, all because of an issue with counsel. So, Your Honor, I put in my motion what the evidence would show, and then I went through for myself to make sure I could actually prove each thing I said the evidence would show. So, for Ms. Harmon will come in and indicate that the state refused to provide discovery to Ms. Bell, despite being asked multiple times, Your Honor, over 3 months, repeated demands, And it'll start out with Ms. Ortman's March 4th email to Mr. Standiford, basically saying that she's not going to recognize that. She's not going to give her discovery, which she never did. Then there's an email on 4/8, which Ms. Harmon and Ms. Ortman are on, asking that they give me discovery. Ms. Harmon is charged with giving discovery, Your Honor, so why didn't she? And I'm sure she's going to testify that she was told not to. And Mr. Standiford, I reached out, asked for interviews, still not scheduled. So some of these exhibits, Your Honor, Exhibit 2, Exhibit 3, Exhibit 26, Exhibit 29, Exhibit 30, Exhibit 31. Ms. Harmon will testify to all of these and answer the questions about why they're not cooperating with the demand discovery of Ms. Bell, and that she was told not to. And then on 7/9, the E12 about the settlement conference, and then the email to Beauchamp, E32. So the ones, and then I was removed from correspondence when the court appointed attorney deliberately included me. That's Exhibit 4. I was refused. I asked to schedule interviews on April 8th, April 18th, April 29th, May 1st, May 13th, June 26th, July 4th. Barry Standiford asked 4 other dates. I'll get those dates for you. But he asked 4 other dates, 3/4, 4/9, 4/17, 4/30. And they suddenly stopped starting May 6th. So Ms. Harmon said she was arranging Palmer's interview on May 6th. It never got scheduled, Your Honor. And Ms. Harmon's the only person that can tell you why. So it's like, well, is that a big deal? Yes, it is. And there's case law because the state, there's 2 reasons. They have to be diligent in scheduling interviews, and they can't prevent access. And also there's case law on how it would render the plea, which we had a settlement conference, ineffective assistance of counsel by blocking interviews before the plea expiration, and it weighs on the voluntary intelligence of the plea, which we have a settlement conference. So that's Harmon, Your Honor. She refused to engage in any plea negotiations. Number 5, objected to Ms. Bell appearing by the plea deadline during the plea. There's multiple exhibits. Harmon and Collins admit some of them. Frustrated the preparation of defense and choice of counsel by defense team, E19, E22, Exhibit 4. Ms. Harmon's a witness to all this. She's on a lot of the pleadings. Harmon's role, Your Honor, was to arrange interviews, provide pleadings, and give discovery. The reason she did not do that, and Your Honor, on these exhibits, it shows that I am an attorney of record. You have to deliberately exclude me. She included me in May, she excluded me in July, so she's going to answer why. And if her answer is because Ms. Ortman told me the case law shows how that's a right, it's an interference with the right to prepare a defense, the right to counsel, and it's a due process violation. And so that's Harmon. So Collins comes in, and he is witness interference. And Judge, the state didn't say, oh, you know what? Barry's removed. Let's fix this. We can fix this. They didn't say, you know what? Let's extend the plea. Let's go to the settlement conference. You know what? Ms. Palmer, we can get her in 48 hours. Do you know when I reached out? Boom, she was immediately available. 48 hours to get an interview with her. And they couldn't do it for 4 months. So with that being said, let's just get her into an interview. We'll give you discovery. No big deal. So they said, no, Judge, we don't want to give her the discovery she's been asking for 2 months. 4 months. I'm sorry. No. So they played cat and mouse. And then they sent out letters to witnesses, Your Honor, telling them not to cooperate in a defense interview without the presence of the state and indicating their preference to be there and demanding to schedule it. That is interference. And Collins and Harmon and these witnesses will testify. Your Honor, that's a Sixth Amendment violation, and it's highly relevant to the issue before this court. This isn't a trial. We're not talking about whether or not she had drugs and child abuse and a search. That's not the issue. The issue is prosecutorial misconduct. So the witnesses that are relevant aren't going to be the fact witnesses for trial. So the state's analogy that, hey, this isn't about a trial, this isn't about the elements of the crime, it's true. That's true. But they're missing the whole point. They don't understand how to apply the law. We are having a hearing on prosecutorial misconduct. The witnesses that were a part of this misconduct, that witnessed this misconduct, are going to come in and lay the timeline for this court. And in the closing, Your Honor, I will give you all of the case law that answers their ultimate question. Well, why does all of this stuff that she's done matter if since July or August she's giving you stuff, for example, she's preparing her prosecution and complying with 15.1 and there hasn't been anything since. There hasn't been anything since because the case took a complete pause. So we're no longer here and advancing this case and expediting it for Ms. Logan. All been derailed. It didn't have to be. So that's why there's no misconduct. So while it might look to the court like, hey, this problem's worked itself out, first of all, the problem's already occurred, and it's what remedy the court's going is available to the court, because the court has no authority to just demand that the state reopen the plea. There's case law on that. They basically overturned Donald, and that you cannot make the state reoffer the plea, so you can't fix it that way, Your Honor. The only thing this court can do is order whatever prosecutor is assigned to participate in good faith, and given the history of this prosecutor's office, that's not going to happen. So disqualification is favored. So it might not be apparent why these witnesses are relevant, but once you get them on the stand and you go through this timeline and the closing comes in and you see all the case law on the timeline, it's going to be clear. It's going to be more confusing if all you have is 100 exhibits and I go through them one by one for the next 4 hours and give you the case law, and then you're going to be left with questions for witnesses that we could have called and asked them directly, because they're vouching and I'm speculating. So that's not appropriate for the court. So the reason why these are important isn't just like, well, you know what, she didn't communicate with you for 4 months, but there's no prejudice, and going forward it looks like she is. That doesn't solve the problem. And that will make sense in my closing, but I need to get the evidence before this court. And honestly, Your Honor, to create a proper record, I think this is a significant issue. I've never seen this type of interference with counsel. And I understand that it's not common up here. It's more common in Maricopa County. But if this is what's going to happen with this office, when an attorney comes on pro bono and represents somebody and takes on a case and works with the public defender and drives 2 hours to do interviews, and this is what we encounter, this is an issue of statewide importance. It's also, I think, an issue that this court should want to put an end to immediately, because attorneys that come on pro bono, reduce fee, work with the public defender should not be treated like this. So I think that the court should be very curious what exactly has gone on in this case, so that you can prevent it. Not in future cases, you can put it into it and you can remedy it, so that the Miss Lopez is finally treated fairly, and that the public can be confident that this is a fair proceeding and avoid the appearance of impropriety. Even at the end of the day, Judge, if you can say, listen, by the letter of the law, they skate through by the grace of God, so technically it's going to be okay. It really matters what the public thinks. What has happened here, what you will hear today from these witnesses and these exhibits, I think once you hear all the case law, you will be troubled by it. So bring these witnesses in, hear from them. There is no error in hearing from these witnesses. The Sixth Amendment literally is the right to compel witness testimony. That's what the Sixth Amendment is. So the state's argument that you can't use the subpoena power for discovery misses the mark again. Yes, we can subpoena witnesses to testify in a hearing about prosecutorial misconduct that witnessed the facts. So yes, the purpose of the Sixth Amendment is to compel witness testimony, which is what we're doing. We didn't use it to compel documents. So, Your Honor, in order to create the proper record to protect your decision one way or the other, whether it be against the state or against me, you want to hear from these witnesses, or we open another issue on whether or not denying access to these witnesses, and we come back possibly and do it all over again when we're here now. And the constables already served these subpoenas twice. The clerks already issued the subpoenas. It's a huge waste of time and resources, and this county's already wasted a ton of time and resources hiring private attorneys, bringing Skybelly in, using the constable twice. These officers have been sitting out here for 2 hours. There is no error in putting these witnesses on the stand, but it could be error if you.
Ms. Skybelly?
Yes, Your Honor. I believe that the fact that the court needed to ask this question is a point in itself, that defense has failed to show that this testimony is relevant and necessary and exculpatory. As I explained, it needs to be relevant in regard to the underlying case. I do understand she's alleging that there's some sort of prosecutorial misconduct. However, that is not the case. It's simply a fishing expedition. She's trying to find it, and it doesn't exist. Mrs. Ortman might have some comments on the criminal end of this.
And Your Honor, from the criminal side of it, and beyond, to address how this isn't relevant, Your Honor asked a question about the plea. In one of my responses, I had said that I would reopen it for the purposes of Donald, because Donald has not been conducted in this case. And so I had said that I would do that, and that's something that I have every intention of doing. Miss Harmon and myself and Mr. Collins and the Healy County Attorney's Office staff testifying is not relevant to any underlying motion, substantive issue in this case. She's trying to to loop in these accusations, because that's all it is accusations of prosecutorial misconduct. The record doesn't support that. The case law doesn't support what she's saying. Harmon and myself and Mr. Collins and the Healy County Attorney's Office staff testifying is not relevant to any underlying motion, substantive issue in this case. She's trying to loop in these accusations, because that's all it is accusations of prosecutorial misconduct. The record doesn't support that. The case law doesn't support what she's saying. And so once we get to those motions, we'll argue them. And so I'm not trying to jump in and argue the criminal side of this now, but it does not go to any actual issue with any substantive issue in the case. And further, Your Honor, she's failed to mention to the court that we have done defense interviews in one of the cases, which is the second case in time, which is the second case that needs to go to trial. She speculates as to why all of this misconduct that was happening prior stopped, according to her, the moment she was appointed on the case. She was appointed on the case. The state's position in this criminally has always been that she was NAP counsel. And NAP says that the state can work with primary counsel, which is what Mr. Standiford was. She is ignoring an entire portion of State v. NAP that says, in order to avoid confusion, we can talk to, and we have one point of contact, which is the primary counsel in the case, which is Mr. Standiford. That's been my position this whole time. And that's what I put in my motions. So that's on the record. I don't dispute that. That's been my reading of NAP. If the court tells me that's incorrect, it's incorrect. But the bottom line is once she became counsel, all of the discovery started going to her, because Mr. Standiford was no longer the lead and primary counsel in the case. She's failed to show that there's been any interference in this matter. And so that's getting really into the weeds with the felony criminal side of all of this. But the bottom line is she has 99 exhibits for the court to consider. That contains many of the emails, that has letters from all of these people. So to say that she needs to have Miss Harmon take the stand, or she needs Mr. Collins to take the stand, it's just her further fishing to try and hopefully show that me personally, I've done something wrong, because this isn't an attack on the actual substance of either of these cases. It's an attack on me personally, which is unprofessional. And that does support my argument of harassment. And lastly, Your Honor, she hasn't requested a single defense interview in the case that actually needs to be set for trial, because that's been the state's position for months. So we just need to have this set for trial, because the pleas expired, the settlement conference didn't occur, the plea expired, we just need to set this for trial. And so she's making this big deal about the fact that she hasn't gotten defense interviews in the second case for trial, not the first case for trial, not the case that we actually need to do defense interviews on, the second case for trial. So, and she's also ignoring the fact that the state did do defense interviews. And one of the things that I am very aware that NAP counsel can do, so while she was NAP counsel, the state didn't interfere with her ability to conduct the defense interviews. I agree that's something that is appropriate for NAP counsel to do. Primary defense can have someone who's not even an attorney do these defense interviews. I know that I've seen investigators who've been appointed or who are associated with the defense who've conducted defense interviews. The defense counsel can have whoever they want to do defense interviews, and that's exactly what they had here. Mr. Standiford clearly wanted Miss Bell to do the defense interviews, and that's what she did. So she's failed to show how there's any interference, how this is even remotely relevant to any of the actual underlying issues and any substantive issues in this case. And so, Your Honor, it's just her further trying to get information to make the Healy County Attorney's Office and myself, I mean, just count the number of times she mentions my name in these motions. Like, I'm the one that's on trial here. Like, I'm the criminal defendant. When it's her client who should actually be the focus, who actually has done something wrong here. And so she's just trying to shift that direction, and she's trying to get the county attorney's office removed from this case. She's asked for the Arizona Attorney General's office. She's asked for $50,000 in damages. I mean, all of that goes to show that this isn't about what she's trying to make it, because that's all it is her trying to make it into something. But that's not what it is. So, Your Honor, I'm asking that the court do as Ms. Sabelli says, and that's how it goes to show that none of this is relevant. None of this has anything to do with it. And these witnesses certainly are protected by work product and certainly should not be taking the stand.
So I'll give you a chance, but I've got a follow-up question. You mentioned settlement conference. Is there is the state amenable to a settlement conference? You've indicated that because there's been no Donald hearing, that you're ready to make the plea available because there hasn't been a Donald hearing yet. Is the state amenable to a settlement conference?
Yes, Your Honor, because that's basically just an extended Donald hearing. I mean, it's a much more in-depth Donald advisement. It's just off the record. And so frequently I use the purposes of a settlement conference pretty akin to Donald. So yes, Your Honor, I would.
Okay. Ms. Bell, you wanted to say something. I'll let you say it, but before I do, what I think I'm going to do is I'd like for both sides to give me a case or two that they want me to go back and read during the break that will show why I should either quash or shouldn't quash these witnesses. And what I'm gathering from the defense argument is, even if since July or August or whenever Mr. Standiford got out of the case, even if the state has done everything that has not sought to prevent Ms. Bell from having input into the case since that date, that its argument that the state did so for the 4 or 5 months or whatever it was before then, that alone is enough to justify the calling of the witnesses. Essentially, that prejudice doesn't have to be shown. So I think that's one of the arguments that I heard. And so there'd be a violation of the right to counsel, even if it's fixed after that. So from the defense, I'd like to maybe, if there's a case you want to have me focus on in the 15 minutes or so I'm going to take during the break, I'll invite you to do that. And for the state, the same thing. Is there a particular case that you want me to go back into? You'd mentioned the State v. Fish, I think it's Fish or Fisher case from Maricopa County. You probably have a citation in one of your briefs, but the briefs are voluminous at this point. So if you've got a case or something that you want me to look at in the break, think of that. And so, Ms. Bell, I said I'd let you comment again. Go ahead.
Judge, the state keeps arguing she hasn't proven interference. This is speculation, et cetera, et cetera. All I have to prove that these witnesses are relevant and material. Relevance is a very low standard, that it makes a fact more probable than not. And so they keep trying to say, well, she hasn't proven it. Judge, that's the purpose of the hearing. That's the purpose of calling. It's, of course, I haven't proven that yet, because the emotions and what we write and then are not evidence. That's argument. What we argue before you is not evidence, Your Honor. So all you're going to be left with is 99 exhibits. Quite frankly, Your Honor, they're not going to help the state. In fact, the witness testimony, it might actually help the state and hurt me. However, our duty before this court is to get to the matter of the truth, right? Not to mislead the court, not to be the most ingenious at playing the game. So if my argument that Miss Ortman told Miss Harmon not to, at least that's the appearance, which all I have to do is meet the appearance of impropriety, which is met. But if Harmon comes in and says, no, Judge, I just didn't, that will affect the court's ruling in terms of impropriety here. Why wouldn't you want to hear that from the witness's mouth? You're going to have two attorneys arguing at you what this person did, and you have to find out which attorney is telling you the truth. So the purpose of the hearing is to admit the evidence to prove it. By depriving me of these witnesses, then you deprive me of the evidence, and then the state comes in and argues, it's speculation. She doesn't know. She hasn't proved it. So preventing me from calling these witnesses allows the state to tell this court that I haven't proved it. Of course I haven't proved it if you don't call the witnesses in, right? I can admit this evidence and we can speculate, and all I have to do is show an appearance of impropriety. Which, how is the state going to explain from May 6th through July 5th, 18th, they made zero effort to interview Palmer. So I want to address again the state's presenting misleading facts. She said, Judge, she interviewed Baxley and Andrade. I submitted Mr. Stanford submitted an email to Miss Ortman. I'll find the exhibit that said there was a lack of notice. That was from the Alvarado case, Your Honor. That means that the intake officer or an officer that transported her from this jail, which we're trying to track down, it's either Hayes or Mays. The state said they were arranging that interview, but then Graffia said that no officer exists by that name. So I don't know if they were or not. But Officer Hayes or Mays transported Miss Lopez to the jail. Miss Palmer did the inventory. According to Alvarado, if a defendant does not have notice or warning, it goes to the voluntary act. And the Alvarado on the west coast side of the country seems to follow Tippett's and one other case, in that if a defendant is not given notice, is not given a warning about the consequences of bringing contraband in, then there wasn't a voluntary act, and therefore they have a defense to count 2, which would expose her to 10 years presumptive prison. The person that was relevant, so Baxley wasn't there. He said he didn't know. I came to the interview with the GCSO policy that we got through public records request, which ironically, I knew what happened, mirrors the Alvarado rule. It basically tells the officer to ask the witness if they have anything on them. That's not coincidence. Policy and procedure of sheriff's office generally tend to follow the case on point. So I wasn't really quite surprised. So I come to this interview, Your Honor, with the GCSO policy. Baxley knows nothing. Absolutely useless. Palmer wasn't there. Andrade followed Palmer, knows absolutely nothing. Both of them said in their interview that Palmer was the person to ask. So then I come out and I tell Miss Ortman that we want to interview Palmer. Your Honor, the email follow-up on 5/13 also expressed, which is an exhibit, the anticipation of Palmer's interview. I also followed up with Miss Harmon on the 6th about, are you still arranging Palmer's interview? She was identified as the most important witness. It was clear. And if it wasn't clear, it was clear in the deviation request. And if it wasn't clear in the deviation request on 5/13, then it was clear on 6/10 email following up on, where's this witness's interview that you said you were arranging? It's been a while. And then it was made clear in the Trevis letter. It was made clear in the remand, and it was made clear on July 4th. There is no doubt the state knew that this witness was the primary witness. The other 2 witnesses did not give us what we need. We wanted access to that witness. As soon as that became clear on 5/10, they suddenly stopped. Because that witness jeopardized their case. Or it's because Barry Sandberg went over Jessica Ortman's head because she was being vindictive, and she didn't like if the plea got expired, because if you remember Kayla Evans, they were adamant that it would not go past 6/3, which Beauchamp went over it. So for some reason, which is unknown, which we're going to draw from these witnesses, she retaliated. So, Your Honor, so saying that, well, she did these interviews with Baxley and Andrade is misleading. She knew we wanted Palmer. She knew they were exculpatory in this case law. Then she goes on and she's like, well, she's not really scheduling the interviews with the witnesses that are most important. She's not a defense attorney. She doesn't dictate the defense. She doesn't get to decide what's important. Miss Lopez is probation eligible on the first case. Her co-defendant just got probation with the prior, with the same allegations, the same count, the same kid. Her exposure comes from the second case, and if Palmer did not tell her the consequences are after she has a defense. And in response to being part of our interviews as work product, Ms. Ortman filed a motion in limine for a trial that hasn't even been set instead of spending her time arranging interviews. She also gave us a picture of the sign of the jail, which again comes from our work product. So she's been preparing her case, and she's misleading the court to act like she has, in good faith, arranged these interviews. It will all come together, regardless if you let me call these witnesses or not, in this PowerPoint. I think, Your Honor, at the end of the PowerPoint, you're going to have questions for these witnesses. And quite frankly, those questions are going to help the state more than, or hurt them, because you're going to want to know why. It's going to be a bad answer, it's going to be a good answer, and you're going to decide how to address the state. So she's saying, well, she did these interviews. She also said she hasn't asked. I don't have to ask to do interviews for the state. For some reason, the state does not understand. It is clear as day. There are 50 cases. I actually wrote them all down. I reread them all last week to make sure they all said what I thought they said. 50 cases that say that this defense does not have to have the permission of the prosecutor. We do not need the consent of the prosecutor. The state cannot interfere. The state to come in and say, Your Honor, ever since she became an attorney of record on July 15th, which is false, she doesn't understand that. When I give you all the case law preceding that, it's just going to obliterate the defense. There is no logical argument for the state's interpretation of that. Zero. There's just no way you're even going to be able to help the state in that point. You're just going to have to look at her and say, I'm sorry you don't know the law. It is not disputable. Her interpretation that I have just as much, only the same rights as a private investigator as NAP counsel, is not only not said in NAP, but it is just obliterated by the Supreme Court in every single circuit in this country. So no, she's wrong. She misstated the law again. So I do not have to ask them. The state did not say, hey, let's make this right. I will cooperate in a 17.4. Your Honor, a 17.4 is not a extended Donald advisement so that the state can check a box and say, see, Your Honor, let us out of our vindictive prosecution. We did a Donald advisement. Because we actually already shot ourselves in the foot and pulled it, and now we have a vindictive prosecution claim, and we'd really like to get out of that. So could you just let us check a box, and we'll show up and offer that and just do a Donald advisement? We're not actually engaging in a good faith settlement negotiation. It's not a Donald advisement. It's a settlement negotiation. She just told you she's willing to go for a Donald advisement only, not to engage in settlement discussions. The problem, Judge, is even if that's the remedy you wanted to give in this case, the appearance of impropriety in your level of misconduct in this case will prevent you from allowing the state to go to the settlement conference because of everything that's happened. There's only the least sanction you can oppose is disqualification. The second least erroneous is a 15.7 sanction. I'm asking for 50 grand because I told Ms. Ortman on May 10th that I was doing the 091 case pro bono. I was doing all of the work. There's no question the state did not know that. I filed the motion to extend the remand. It was signed on my letterhead. I did the interviews. I scheduled the interviews. I wrote the 14-page deviation request. I wrote the remand. The state knew that. In fact, they admitted in their response to Mr. Sandiford, which, by the way, he freaks out, writes his response apologizing for God knows what. But she says, you are appointed on. This is your case. You need to start working or I'll report you to the bar. It was clear I was doing all of the work. It was clear by Barry that he said, stop interfering. Miss Bell has Miss Lopez's trust and confidence. She interfered with the lead counsel. Coming in and saying, I'll go to 17.4 to give a Donald advisement so that way maybe I can help me with my vindictive prosecution argument is not an appropriate remedy. The argument, well, she hasn't proven the interference. That's the purpose of these witnesses. My burden to get these witnesses on the stand is just to show that they're relevant. Harmon was responsible for interviews, pleadings, and giving discovery. Those are all the admitted exhibits. That's an undisputed fact. So if she was not doing that, then we get to hear why she was not doing it. And if it is because what I suspect that she was told not to, that is interference, that supports the dismissal, and that's how we prove it. The state is trying to prevent the evidence from coming in. So if you want me to find a case, I'm going to have to go read my pleadings. So there isn't just one case, Your Honor. It's a multitude of cases and a whole bunch of different fundamental rights of a defendant, the purpose of this hearing, and then the state just keeps misapplying the law. They're trying to get you to apply work products that apply to a tangible document to a physical person's testimony. Saying, and if, even on the state's best day, it could be work product. Claver v. I think it's Ozal says that when the state engages in unprofessional or misconduct, work product is waived. They won't get it because it's not possible for a physical person's testimony. But even if they could, the unprofessional conduct would vitiate the work product privilege. So, Your Honor, if you want me to find one case, I think it's going to be nearly impossible because there's 50 cases alone on witness interference. I have like 26 cases that I narrowed down just on witness interference, vindictive prosecution, right to counsel, not counsel. There's probably 100 cases that you would have to review to understand exactly how all of these come together and why these witnesses should be put on the stand, which would be an unfathomable amount of time. So I can't narrow it down to one. I would be better off briefing it, which is what I wanted to avoid, but I will if you want me to.
Okay, thank you. Ms. Cabelli?
Yes, Your Honor. Mrs. Bell just indicated that she was hoping to find something from the testimony that she assumes is correct. What was the word that she used? As I suspected?
Yeah, suspected.
As I suspect. The case law is very clear in that, and that is one of the cases that I will give to you during the break. But as I mentioned earlier, if they don't have something of substance, factual foundation, they can't have the testimony. They need to show something of substance. It can't just be some sort of speculation or assumption or what have you. Again, this is a fishing expedition so that she can hopefully find prosecutorial misconduct, which has not been done here.
Chairman of the Superior Court, a defendant should not be forced to...
Your Honor, I'm sorry. That was just highly unprofessional.
I'll give you a chance to cite something later on, but don't interrupt. Go ahead.
Do you have something else?
Ms. Cabelli?
We do have the two cases. I'm not sure how you want that, but Mrs. Ortman also has something to add.
And Your Honor, I think we need to stress that none of these witnesses are substantive to any of these cases other than Officer Palmer. That's the only substantive witness. That are Miss Harmon, Miss Price, Mr. Collins, none of them.
Well, and I think the only thing that's at issue in the motion that's I'm going to roll on first is Mr. Collins, Miss Price, Miss Harmon,
Right.
whether or not they can be called.
Yes. And
So, and certainly they don't have any. I think I agree with you. They don't have it. It doesn't appear to me that they have any substantive information about the underlying alleged crimes. And as I understand the defense argument, the evidence that they have, or that they may have, is regarding her claim of prosecutorial misconduct.
yes, but the thing is it has to go to the substantive case. It's just it doesn't go to that, and so Ms. Sabelli is handling the rest of it.
Yes, Your Honor. That's the second case that we're going to provide to you, State Tuzin, and in that one there was an indication.
Give me the site.
Yes, it's 118 Arizona 205 208 1978.
Okay, thank you.
Do you want the second one?
Yes.
It's 498 U.S. 292 1991. And that's USR Enterprise Incorporated. That one's talking about the fishing expedition, and Suzanne is discussing the compelling need for the testimony that defense needs to demonstrate that they can't obtain it from any other source and that it's necessary and relevant.
Okay, thank you. Ms. Bell, you said there are 100 cases, but then you thought of one that you want me to look at during the break.
So, Judge, this case actually addresses about the defendant's ability to prove before calling the witness misconduct. So, first of all, the state said, well, she keeps saying she hopes that she thinks they're going to say this. First of all, I don't know what the witness is going to say. They haven't testified, and they've refused to do an interview, and the state hasn't complied with 15.1, and the public records request is still outstanding. So, of course, I do not know what this witness will testify to since the testimony hasn't happened, but I have 99 exhibits establishing foundation for these witnesses. And Turbin v. Superior Court, 165, Arizona, 195, page 198, 1990, appellate court. A defendant should not be forced to attempt to prove that there was actual indiscretion or impropriety by the state. Evidence of such conduct being under the control of the prosecution would be well nigh impossible for a defendant to bring forth, which you're seeing here. Collins wants to testify, but the state doesn't want him to. So they control these witnesses. They control 15.1. They control the public records. They hired a firm. So saying, Judge, she doesn't know what this witness is going to say because we've stopped her from interviewing it. We've engaged in a role of silence and coordinated effort. All this is condemned. So the fact I have 99 exhibits as an offer of proof as to why these are relevant for prosecutorial misconduct. This is not a personal attack on Ms. Ortman. It doesn't matter which prosecutor within this seat. When you are alleging prosecutorial misconduct, you scrutinize the conduct of that prosecutor. Unfortunately, that means Ms. Ortman's name is going to be mentioned as she is the prosecutor. So this argument that it's a fishing expedition, there's 99 exhibits that show it's not a fishing expedition, and it's a foundation, and that these witnesses know what Ms. Harmon was doing and prevents vouching and having the court found its decision on speculative facts. I will read my response to the motion to quash. Again, I filed this similar motion in 2 other cases where I subpoenaed prosecutors and paralegals. I'll look through those for my response there because those got granted. So I'll figure out if I didn't cite to a case. But I'll get that case, but I've got to go through some pleadings. And I don't know if I can narrow it down to one, but I will absolutely try. But at the very end of the day, I'll rely on the 6th Amendment and the Ms. Lopez's right to present evidence and to compel witnesses to testify on her behalf. So at the end of the day, the 6th Amendment gives her that right. Everything else would just be citing to the 6th Amendment and the right. And the state's argument that the defense has failed to present evidence of actual misconduct before the witnesses take the stand and exactly what these witnesses will testify is due to a coordinated wall of silence and the fact that Turbin v. Superior Court says, of course that's going to happen. Of course the prosecutor's not going to say, here's all the evidence of my misconduct, go show the judge, right? Because that's going to get her in trouble. Oh, I forgot to mention that Ms. Ortman filed a bar complaint against the opposing counsel, which adds to the disqualification issue and the 17.4, which I'll get into later. So, of course, I don't know what these witnesses are going to say. But all I have to show is that they're relevant. The compelling need is that they witness prosecutorial misconduct, their material, because they will put context to their actions that are the exhibits that have already been admitted and prevent vouching. So compelling need and materiality and relevance have been met.
Okay. Counsel, I'm going to recess. I'll at least take a look at these 3 cases, and we'll come back and I'll roll. Thank you.
Thank you, Your Honor.
All right.
Please be seated. Okay. Let's go back on the record in the State v. Lopez matters. The record will reflect the presence of the defendant, her counsel, and counsel for the state. So as to the motions to quash the subpoenas, the court notes, and I've not gone through and read these 98 exhibits. As I understand them, and as defense counsel has argued, that at the end of the hearing, the court I think the statement in context was, at the end of the hearing, even if I don't allow the witnesses to testify, I'm going to want to hear what they would have said because of what is contained in these 98 exhibits. I think that one of the considerations for the court on whether to require these witnesses to testify is that is the information available from other sources? As to Nikki Harmon, the legal assistant in the county attorney's office, and maybe let me back up. I believe, and I think it's the Murray case that distinguishes between prosecutorial misconduct and prosecutorial error. And as I understand it, basically prosecutorial misconduct it's basically an error on behalf of the prosecutor that affects a constitutional right of the defendant. And that generally also would implicate an ethical violation, whereas prosecutorial error is some mistake on behalf of the prosecutor's office that does not reflect an ethical error, even though it might go to a constitutional right being violated by the defendant. So to the extent that is the case, what Ms. Harmon would testify to, I'm assuming, and again, I haven't read through all these, I barely even skimmed the titles of these exhibits, but it's alleged that either she intentionally, based upon something that she was told, did not set up interviews, or the other explanation, I suppose, would be that if in fact these interviews weren't set up after they were requested, that there was some sort of inadvertent mistake. It doesn't seem to the court that necessarily, what she says on that may not matter as far as whether or not there's prosecutorial misconduct, or whether there's prosecutorial error, or whether there was no error at all. And then as to Mr. Collins, I can only assume that among these 98 exhibits that there may be some indication that maybe he has said witnesses, at least it's alleged, I think, that he told witnesses or something not to give an interview to the defendant without the county attorney's office being there. If that exists in an exhibit already, I think it raises the question, is there a need for his testimony if there's some sort of document that says that? And as to Misty Price, who my understanding is, I'm not sure what her official title is, but I think she's sort of an office manager of non-legal staff. I'm not sure what the exhibits are there, and I may not even understand very well why defendant is seeking her to testify, except that I'm assuming that she believes that if she testifies, she'll say, Ms. Ortman or some other attorney told me not to set up interviews or told me not to have staff set up interviews. I think one of the factors the court can consider in whether or not to compel the testimony of witnesses is, again, is the information available from other sources? I also think that denying the motion to quash would be perhaps an extreme action to take, because it basically goes to the county attorney's office's, whether it's exactly work product or not, it certainly goes to, I think it'd be an extreme measure to require them to testify. I am mindful of defendant's argument that well, how else can they prove it unless they have the witnesses from the county attorney's office testify about what they actually did and why they did it. So I do acknowledge that I think that's the defendant's argument, that these witnesses are the only ones who can provide this information. But with everything else that's here today, I'm not sure that I don't believe that that's the case, and so I'm going to grant the motion to quash the subpoenas of Misty Price, Nikki Harmon, and Joe Collins. So that leads us, I think, to the other motions, which are the motion to disqualify, the motion to dismiss, and the motion for sanctions. Ms. Bell, do you have other witnesses that you want to put on the stand in support of those motions?
Well, Judge, by quashing the subpoena, you have blocked the defendant from proving a relevant portion of the case. The state didn't identify any other witnesses that were available to testify in that place. They did indicate there were documents. I think just the admission of the 99 documents show that these witnesses are relevant. If the documents basically tracking their involvement are relevant, then obviously their testimony to those would have been relevant. So I'm trying to figure out what the best course of action is today. So there's three options. The first is to file a motion to reconsider and fully brief it. The second, I've tried to write down the court's logic. I couldn't. I got that it was an extreme measure to require these witnesses to testify, and I'm not sure what the other witnesses that are available in their place if the court found no relevant witness to testify in lieu of Ms. Harmon. It sounds like I think the court's logic is because there are exhibits that we cannot call the witnesses now because there are exhibits that we can just rely on. Did I understand that correctly?
So I think you have to show, the state's argued that one of the considerations the court must take, and I think this is the law, is that the information that you're seeking to elicit is not available from other sources. In this case, I can't remember whether it's 1 through 98 or 1 through 99 have all been admitted into evidence for purposes of this hearing. So I don't think that you have shown that the information you're seeking is not available from those 98 exhibits. And in fact, I think you indicated, which I think leads me to believe that that perhaps you do believe it's there, that if after reviewing these 98 documents, that if I denied the motion, or if I granted the motion to quash, which I have, that I'm going to wish that I would have heard from them. seems to be an indication that the documents themselves should be sufficient to support the case. So I hope that provides some clarification.
Well, sort of, Your Honor. For example, there's an exhibit. I think it's 20 and 20. I know it's for sure 21. I don't know if it's 20, but that goes through. Let me go to it. Filed. Some of the correspondence about the interviews. I mean, really, Exhibit 19 through. I mean, at least 44, probably more. It's got it all outlined. Basically, outlines some of the efforts the defense was making for interviews. So the court's going to have an exhibit on May 6th that says Harmon was working on the interview, and then you don't have another correspondence from Harmon trying to arrange interviews until July 18th. So how does the court know why she stopped arranging interviews? So you're obviously going to have two arguments. One is going to be that she was told, and unless Ms. Ortman wants to implicate herself in misconduct, she's going to argue that she didn't tell her or dance around the issue. I'm not really very sure yet. So how do you know if she was told or not? You'd have to speculate because we don't know.
So if that delay of 2 months in setting up an interview violated the constitutional rights of your client, I guess what I'm suggesting is that I'm not sure that it matters. It could still be prosecutorial misconduct, whether Ms. Ortman said, Ms. Harmon, whatever you do, don't set up those interviews, or whether it was just a sort of a clerical mistake. So that would be the court's response.
I understand that argument, and it's not that I necessarily disagree, but part of my job is also to create record. So obviously, and I was prepared to question Ms. Harmon, and now that these witnesses are not possibly going to be testifying, I'm not sure. I'm trying to figure out the best course of action. So there's like a few that I can think of right now. I'll tell the court what I'm thinking. Maybe you can assist me. So the first one is to file a motion to reconsider, although I'm not sure too much considering you can see the court's point of view. And then if it's denied, I have two options. I can special action the issue because I want to ask these witnesses, or I can just put on the hearing with the evidence that I have. The problem, Your Honor, is the evidence, the other witnesses that are here, the officers, Palmer and Solis, they don't know why Miss Ortman and Miss Harmon stopped. I mean, they also don't know what Miss Ortman told. So I'm not sure that they have the information I'm seeking from them.
So what are you? I mean,
they were for not necessarily. They don't necessarily prove and admit all these exhibits, or can even weigh on it. If I try to show any of these officer witnesses the legal process, they're not going to have any personal knowledge. And again, Your Honor, I can't testify for them. What I suspect is that they were available for interviews, they made efforts, and it's going to establish that, but for the state's delay, they would have been scheduled. But that's just a small portion of the case. The rest, I have to rely on the exhibits and then deal with the prosecutorial vouching that Ms. Ortman is inevitably going to engage in and address any misstatements of fact without witness testimony to combat that. So it makes it extremely difficult to conduct this hearing without witness testimony and only rely on exhibits, because the Sixth Amendment is not substituted. Witness testimony is not substituted by exhibits, and they don't just admit themselves.
Well, they are admitted.
Yeah.
We got 98 exhibits. I think I don't remember. It was 1 through 98 or 1 through 99.
What I'm arguing, just because they're admitted, some testimony I think would have been relevant. The only benefit, honestly, to you precluding me is that the state's not going to be able to rebut the presumption that there's an appearance of vindictiveness and an appearance of impropriety. There's going to be nothing for the state. anything Ortman tells you to try and rebut it is argument, not evidence. So it, quite frankly, very much damages the state. It damages my ability to preserve the record in the event there is a special action right inside, Your Honor, because the state could attack your ruling, and if you were speculating because there wasn't testimony. So I just haven't. Maybe give me like 15 minutes, figure out if I can go forward today or come up with another.
Your Honor.
Ms. Cabelli?
Yes, Your Honor. With the defense counsel's comments in regard to the officer's possible testimony, the state would move to quash those subpoenas as well. At this point, it has become clear that their testimony would not be relevant.
So I guess we're going to do an evidentiary hearing without any witnesses, Your Honor. Is that the state's position?
Don't ask me what the state's position is.
Well, I believe we have an opportunity to respond to that because that was just verbally today. I don't think she represents these witnesses.
Yes, I do.
So at this
So you represent the officers?
Yes, Your Honor. I represent the sheriff's office.
Are these all sheriff's office deputies?
I thought one. I think.
I mean, I
No, one was. I think it might be Palmer.
Yes, Your Honor. They're also jail staff.
I think the city employee, the city attorney, the civil attorney, represents any employee of the county. From my understanding of their.
Well, I was just asking we also have like Glow PD and other places. I didn't recognize the officers' names. Well, let's do this. We are only, and I can only go till about 3 o'clock this afternoon. It was only scheduled to go an hour into the afternoon. We're already way past that. We're already far behind based upon this first issue. Let me ask this so that I understand it. Ms. Bell, essentially, are you going to be calling these law enforcement or detention staff witnesses essentially to say that they were available to be interviewed and that they would have granted an interview? Is that the idea behind it?
Let me look back. I'd have to look back over each of their outlines.
Based upon this first issue. Let me ask this so that I understand it. Ms. Bell, essentially, are you going to be calling these law enforcement or detention staff witnesses essentially to say that they were available to be interviewed and that they would have granted an interview? Is that the idea behind it?
Let me look back. I'd have to look back over each of their outlines.
Your Honor, she just indicated that their testimony would be irrelevant without the county attorney's assistants testifying as well, because it would be hearsay.
I have no idea what she's talking about. Judge, I said that they won't be able to establish some of the accusations. They don't work for the county attorney's office. If the issue is prosecutorial misconduct with respect to interfering with witnesses, not giving discovery, lying to the court, all of these different issues, of course the officers will not be witnesses to that because they don't work there and they were not in court. So while they do have some facts that are relevant, by not allowing Ms. Lopez to call these witnesses and limiting our argument only to admitted exhibits and basically argument, it blocks a substantial portion. I also think it violates the Sixth Amendment. But if I do want to call, it sounds like we have another motion regarding a motion to quash. So we're going to do that first about whether or not.
So what are your reasons to quash the subpoenas?
From what defense counsel has just put on the record, she was indicating that the testimony of the officers would not be helpful if she did not have the testimony of the employees of the county attorney's office.
So that motion to quash is denied. So we don't, it's litigated.
Well, it's due, Your Honor. Can we,
If you want to think of what we can do, we can go ahead and break now, maybe come back at 1:15 instead of 1:30, and you can decide if you want to try to put on as much as the rest of your case as you can, whether it may, given that, and I have an appointment at 3:20, so I can't go the rest of the afternoon. I don't have anything else set, but this was scheduled for, I think, from up till 2:30, maybe till 3 o'clock, and I'm not going to be able to go past 3.
we wouldn't make it through completely. We might make it through the testimony. We wouldn't make it through like the closing. Would it? I'll take the lunch break. I'll try to figure it out. If I am going to try to proceed with calling the witnesses, what I'm inclined to do is, because it doesn't make any sense to move. If I move forward with them, we rely on the exhibits, and I don't know how the court's going to rule. And say you rule against me, and I special action that, then I'll be special actioning the Sixth Amendment right to call these witnesses, and if I prevail on that, we get remanded and come back and do it all over again. It might be better to special action the motion quash, but given that, I think that, yeah, so it might be better to file a motion to reconsider, and if that's denied, I think it might be best to special action it, because if I'm correct and these witnesses should be called, we will be redoing this all over again. This is a lengthy hearing. It's going to be lengthy, even with just the officers and the closing argument, because of the 4 months of misconduct and the case law. We're not going to finish it today.
Okay. Well, then why don't we come back at 1:15, and you can, that gives you some time to think about it and decide what you want to accomplish this afternoon, or whether you want to file the motion for reconsideration, or how you wish to proceed. Anything from the state before we actually break?
No, Your Honor. Thank you.
Okay. So we'll go ahead and we'll recess until 1:15.
Here.
Thank you.
All right.